Hello, my name is Alice Wilk and I am the Chairperson for the Law Community of New South Wales Environment and Planning Committee. In the third part of our brand new web series, we discuss the recent federal court decision, Australian Conservation Foundation and the Minister for the Environment. The facts of this case concern a judicial challenge to the federal government's decision to grant mining company Andreena approval to develop the Carmichael coal mine in central Queensland. The approval was made under the Environment Protection and Biodiversity Conservation Act, and the proceedings were brought in the federal court pursuant to the Administrative Decisions Judicial Review Act. ACF alleged that the minister failed to comply with the requirements of the EPBC Act, including the requirement to consider the proposal in connection with its effects on the environment. ACF was primarily concerned with the likely impacts of the action on the Great Barrier Reef, principally the greenhouse gas emissions arising from the transport and combustion overseas of coal produced at the mine. If built, the Andreena coal mine would be the largest coal mine in the Southern Hemisphere, as well as one of the largest coal mines in the world. Of course, the approval to develop the mine has been met with loud opposition from activists and protesters who consider this development to be a once-in-a-generation threat to the environment. Andreena Kardamis is the CEO and partner of the Environment Defenders Office. She represented ACF in the case that we're discussing today. Thank you very much for speaking with us today, Ms. Kardamis.
Thank you for having me here.
So first off, why did ACF commence these proceedings?
We commenced these proceedings with a few goals in mind. Firstly, we wanted to stop the Andreena coal mine from being built. Secondly, we wanted to draw attention to the environmental consequences of this decision, principally being the inevitable adverse impact of greenhouse gas emissions from the coal mine on the Great Barrier Reef. Thirdly, we wanted to challenge the current state of administrative law with respect to the review of approvals of this kind.
So with respect to administrative law, what were the key issues in this case?
The administrative issues in this case surround the decision-making process of the minister who approved the development of this mine. We argued that the minister did not correctly or fully consider the impact or likely impact of pollution from the coal burnt overseas on the Great Barrier Reef. Specifically, we argued that the minister incorrectly considered that the combustion emissions are not a direct consequence of the proposed action. This resulted in a failure to properly apply the test as required under Section 527E of the EPBC Act. Unfortunately, cases like this are not an easy win for conservation groups like ACF. While there is no significant bar to seeking relief by commencing proceedings, we are limited in the arguments we can make, namely that challenges to a particular ministerial decision must be based on process, not merit. This is what is known as judicial review. In other words, we cannot argue that the minister got it wrong, only that he or she follows the wrong legal process in reaching their decision. These arguments are difficult to make, and it results in a considerably low success rate for conservation groups like ACF.
So with respect to judicial review, what did the court find and why?
Well, on Monday 29th of August 2016, Justice Griffiths of the Federal Court dismissed our case and found that the minister made no error of law in approving the development of the mine. Unfortunately, our case fell down because the court's findings were confined to the limitations of judicial review. In his judgment, Justice Griffiths said that it is important to emphasise at the outset the restricted character of this proceeding. On a judicial review application, the court cannot step into the shoes of the minister and decide for itself whether Andreena's actions should be approved and, if so, what conditions should apply.
Environmental disputes have provided the context for a wide range of administrative law principles. This might be why they have been described by Justice Preston, Chief Justice of the New South Wales Land and Environment Court, as being at the forefront of administrative law. Would you like to tell our audience what is the significance of this case with respect to administrative law?
Yeah, this case demonstrates the limitations of judicial review in environmental disputes. It also demonstrates the important role of relaxed standing rules under the EPBC Act in allowing organisations like ACF to bring environmental proceedings. With respect to judicial review, we raised the cases of Solomon, Sadsad and Singh to try and persuade the court to endorse a form of merits review in this case. Each of those cases espoused principles which support the introduction of merits review for government decisions like the Andreena approval. In our view, these arguments represented the strength of our case. However, the court was bound by the High Court authority of Minister for Immigration and Ethnic Affairs, which sets out the main principles of judicial review. Overall, we can see the court making a clear distinction between judicial and merits review. Unfortunately, the court was not willing to reconsider judicial review or to make an exception in this case.
So I take it that you did not agree with the court's decision in this case. What, in your view, was the key weakness in the judgment? And are there any unclear or questionable aspects in its reasoning?
We think the court missed a key opportunity to hand down an important and much needed legal precedent to finally address climate change under the EPBC Act. We believe the court ought to have found that the Minister did not correctly or fully consider the impact or likely impact of pollution from this development, being the incorrect characterisation of this development's combustion emissions as not a direct consequence of the proposed action. We found it particularly questionable that the judge was satisfied that the Minister did not expressly refer to Section 527E and the impact of the approval in the course of reaching his decision.
We also know that ACF decided to appeal this decision. What were the grounds of appeal and the outcome?
Although ACF was unsuccessful in these proceedings, we were not deterred in our efforts to protect a significant feature of Australia's natural heritage from the harmful effects of climate change. ACF appealed the decision to the full Federal Court of Australia, and our grounds were based on our concerns with Section 527E of the EPBC Act. Unfortunately, the appeal was dismissed as being without merit on 25 August 2017. This means that the decision and reasoning of the lower court still stands.
Very interesting discussion. Thank you so much for joining us today.
Thank you for having me.
Finally, it is relevant to briefly discuss the issues of standing and the potential for merits review under the EPBC Act. With respect to standing, the Federal Government considered amending Section 487 of the EPBC Act, which allows individuals or organisations that have been engaged in environmental activities or research for at least 2 years to bring proceedings under the Act. The effect of the amendment, which later failed, would be to revert to the more restricted person aggrieved test, which would stop organisations like ACF in challenging government decisions such as the Indadi mine. It is uncertain whether this amendment will be pursued in the future. Whether there is a need for merits review under the EPBC Act has attracted academic debate. What is clear is that judicial review in environmental litigation is of little use to organisations like ACF, as it fails to provide an opportunity to question poor decisions made by our government. Provided the Minister has ticked all the right boxes, there is nothing that can be done. Reform requires a legislative amendment to the EPBC Act. Introducing merits review in the EPBC Act would lead to greater transparency, integrity and rigour in the government decision-making process. Notably, it is the view of the Administrative Review Council that as a general principle, any administrative decision that will or is likely to affect the interests of a person should be subject to merits review. It is the view of the committee that this undoubtedly includes government decisions concerning our environment. Thank you for your attention. See you next time.